Alright, today's video is about how credit card and credit card debt is actually a scam. Most people have absolutely no idea how credit card debt is accumulated, what it is, or how it's collected. So here we go. This isn't what people think at all. It's amazing. Alright, so I'm going to use the whiteboard again. One, because it's like my notes, but it's a very visual cue for a lot of people that they like. Alright. When you use your credit card at, let's say, Starbucks or any retail location, who's lending you money? Who's lending you money? Well, the answer to that is that when you use your credit card, the retail establishment is the one who's lending you money. Okay, the way it works is that you apply to a bank to issue a credit card to you. That's the bank issuer. Okay, bank issuer, and that's you. All right. So then what happens is that the retail establishment has previously, when they go to start their businesses, they've gone to a merchant service provider. All right, now that's an agent for a bank. JP Morgan Chase, it can be anybody. A lot of these banks come out of North Dakota. I think it's North Dakota because they don't have, the usury statutes up there are very liberal, and they allow for very, very high interest rates. Right? If you ever notice that, your banks come out of, I think it's North Dakota. It could be South Dakota, but I think it's North Dakota. So anyway, the retail company has gone, retail business, let's say Starbucks, has gone to a merchant service provider to open up an account so that they can accept credit cards. Right? So when you use your credit card at the retail establishment, in this case Starbucks, any old coffee shop, says that becomes a debt. You get the coffee and they get the promise to pay from you. That becomes an accounts receivable that is then sold. This is done automatically through the merchant service provider system when you swipe your credit card. So this is sold at a discount. In this case, let's say 2.9% and 25 cents per swipe. That's called the swipe rate, right? Now built into this 2.9% plus 25 is what's called the interchange rate. Okay, your interchange rate, and there's a whole long litany of different fees because there's lots of different kinds of credit cards, right? You get Discover and Visa and MasterCard and everybody. So, and the different kinds are secured credit cards and so on. So the interchange rates are set by MasterCard, Visa, and because they're the ones that handle, and or Discover, whoever. But these interchange rates are built into this too. In this case, the example is probably higher than that. Nowadays, it's probably 50 cents per swipe and 3.5% or whatever. And who pays that is the retail establishment, because what they're doing is they're actually selling that accounts receivable from the transaction to the merchant service provider at a discount. Okay? So when you don't pay your credit card bill, who sues you? Okay? Who sues you? Well, what happens is when you don't pay your credit card bill, you'll get a letter from the bank. Okay, the issuer that issued your credit card. You get an notice from the bank, right? After 6 months, they have to, under federal law, they have to write that debt off as bad, as uncollectible. They're required to, because they have what's called Settlement Tuesday. And when they have debt, that's considered an asset to the bank, and they're not allowed to overstate their assets to the Federal Reserve on Tuesday. So under federal law, if it's considered bad debt, and if you haven't made any payments for 6 solid months, that becomes an uncollectible debt. And then the bank issuer, this is a bank, okay, your bank issuer has to write off that debt. Well, then what happens? Well, it's sold to a debt buyer at around 4 cents on the dollar. Okay, it could be large companies. You could go out and buy debt from a bank issuer at 4 cents on the dollar and buy uncollectible credit card debt all day long. Anybody can do it, all right? So then what happens is that the trick is that when the buyer buys the debt, it used to be back in the day that there was a group called the National Arbitration Forum, okay? And under federal law, they would send you, the debt buyer would send you a letter. Well, the National Arbitration Forum would send you a letter. And then the NAF would have an arbitration hearing, which is like a trial, because who's going to go to Minnesota, because they're up in Minnesota, right, to defend themselves from $5,000 unpaid credit card debt if they can't afford to pay their credit card? Well, nobody would. Well, under federal law, if there's a judgment entered in arbitration, the issue isn't whether or not you owe the debt or not. That was settled in arbitration. Now the issue is why haven't you paid us? Okay? Well, in 2006, I actually figured all this stuff out, that the National Arbitration Forum was in cahoots with the credit card companies, the debt buyers, and a company called Man Bracken, who is an attorney, I think they're out of Florida, Georgia somewhere, that were part and parcel in our National Arbitration Forum, when in fact all those persons are supposed to be good faith and fair dealing. Those are supposed to be long-arm transactions. But in fact, what the National Arbitration Forum was doing is that they were in business with the debt buyers. They were in business with Man Bracken, who owned these other organizations. There will be a link below, but it comes out of a case. It was brought by the. I wrote all this up and I sent the packet off to the Attorney General for the state of Minnesota. Now, whether or not I'm the instigator behind this, the progenitor behind this particular action, I don't know. But I do know that I did write all this stuff up and sent it to the Minnesota Attorney General back in 2006. It could have been 2007, but it was in thereabouts. And it's a Minnesota District Court case at 27 CV 0918550, and I'll give you the link down below. And you want to read that complaint by the Minnesota Attorney General against the National Arbitration Forum and all of these other. Well, they weren't really alter egos, but these people were working in coordination to screw the consumer, right? So they got a consent decree against them. So anyway, so now we'll just say that the National Arbitration Forum step is gone. It substantially is gone. So the buyer then would hire, the debt buyer would hire an attorney, and the attorney sues you. The problem is that this debt buyer who bought the debt from the bank never bought the debt from these different merchant service providers. Because what happens is when you buy this debt, when that accounts receivable is sold, the merchant service provider bank then lends money to the business, right? And if there's a rollback, and let's say there's a charge back on the credit card, that money goes back to the merchant service provider bank. The merchant service provider is an agent for a bank, okay? So the rule against what's called a holder in due course is what we're talking about here, is if in fact this bank issuer had actually purchased these individual debts from this merchant service provider bank, and within, it has to be made for value, it has to be done within 6 months, there can't be any default, and so on, so then they would have what's called holder in due course status, right? And then they would be able to collect, and that means there's no defenses. The problem with that is it can be very easily abused, and Federal Trade Commission Rule 433 got rid of that with respect to consumer debt. Okay? So that's what happens is that the debt buyer who buys your debt at 4 cents on the dollar, who quote, buys that debt from the bank issuer didn't buy that debt. Now, I can only speak to Colorado, but all of the consumer laws are going to be substantially the same regardless of where you are. When you enter into that contract with the bank issuer that gives you the credit card, they're not, it's called a material omission of fact. They're not fully informing you as to the nature of how credit card debt works. Okay, so when you're looking at defenses, right, it says fraud that induced the obligor, that's the person who owes the money, to sign the instrument without knowledge of its character or essential terms. Okay? This all moves towards the fact that if you're not a holder in due course, which they're not because it's outside of 6 months, it's been written off, it's bad debt, right? And it's defaulted, then that means then that anybody who sues you is subject to all defenses, personal, real. All right? Now, the real defenses are infancy, in other words, somebody who's underage. This is duress, somebody's being threatened to move into the contract. Legal incapacity, in other words, if they got diminished capacity like Biden shouldn't be allowed to engage in anything. He's got diminished capacity, he's got dementia, and he couldn't be held in a court of law to be responsible for any contract he would enter into. It says illegality of the transaction, you can't be engaging in a business conversation. Let's say you're trying to sell drugs by contract. Well, it would be unenforceable, you can't do that. And or fraud. Okay? Those are the real defenses. It says then you have personal defenses. And once again, this is called fraud and inducement, misrepresentation, and failure or lack of consideration. And that's really what's happening here, is that the buyer that's suing you, he may have paid value, but the 4 cents on the dollar, but the bank issuer didn't. The bank issuer, the person who's selling that debt to the debt buyer, doesn't own that debt, and they're subject to that. So in Colorado, and I'm sure that the consumer laws, in Colorado it's 516-111. It's the Colorado Fair Debt Collection Practices Act, right? So what happens is that there are a litany of things that they have to do, and I'll read these, and I'll give you the link below to this. But they have to produce a copy of the contract, account holder agreement, or other writing from the original creditor or the consumer evidencing the consumer's agreement to the original debt. Okay? They have to have a copy of the assignment. In other words, the debt buyer, they have to show that they got the debt that they're trying to collect from you has to have been assigned from the bank. And that's a very difficult, they don't have that usually, all right? A copy of the assignment or other writing establishing that the debt buyer is the owner of the debt. If the debt was assigned more than once, each assignment or other writing evidencing transfer or ownership must be attached to establish an unbroken chain of ownership beginning with the original creditor. Who is who? Who's the original creditor? In our case, Starbucks. Starbucks is the original creditor. So they have to show the chain of evidence from Starbucks to the merchant service provider, to whomever it is that bought the debt, that it ultimately ends up at the issuer bank, that then goes to the debt buyer, that goes to the attorney to who sues you. Well, good luck with that. All right? So, beginning with the original creditor to the first debt buyer and each subsequent sale. All right? Prior to the entry of a default judgment against a consumer and a legal action on a debt owed by a debt buyer, the plaintiff shall file with the court evidence that satisfies these requirements that were previously mentioned. This is the amount and nature of the debt includes the amount due at charge-off. Say they got charged off by the bank issuer, right? So the amount due at charge-off if the balance has not been charged off, and itemization of the amount claimed to be owed, including the principal, interest, fees, and other charges or reductions for payment made or other credits. All right? In the absence, here you'll love this. This is part 4. In the absence of evidence required by these previous subsections 2A, 2B, and 3 of this section, an affidavit does not satisfy the requirements of these subsections. All right, so to recap, they got to bring in a copy of the original contract, the assignments of all, the chain of custody, the assignments of the debts, and the amounts due at the charge-off in the bank. And these debt buyers and the attorneys who work for them, they never have this paperwork. So what you need to do is you need to send them a letter as soon as you get a letter from from a debt buyer that you owe some debt. You demand, you got 30 days to do it in. Okay, it's 15 USC. When they send you a notice of demand, right? So they send you the attorney, the debt collector, whoever it is, sends you a demand for payment. You got 30 days under 15 United States Code 1692G to send them a letter saying, hey, I want to see the original contract, and I want to see the chain of custody, the assignments all the way through. All right? And if they can't do that, they're required to, they cannot collect on that debt. They cannot collect. All debt collection must stop until they're able to prove that chain of custody from the original creditor all the way through to the debt buyer or whoever it is that's trying to sue you to collect on that debt. All right? And that's a simple letter to be able to put together. I want a copy of the contract, and I want proof of the chain of custody that you owe the debt, and if you don't have it, leave me alone. And never talk to them over the phone. Never ever talk to a debt collector over the phone. Tell them that they have to provide, all correspondence has to be done in writing. Right? And then you'll make that debt. And if you go to settle a debt, you can settle a debt for very, very cheap. They bought it at 4 cents on the dollar. So they might very well be willing to settle at 10 cents on the dollar. If you owe $3,000, they say, well, I'll give you $500 today. Whatever. Right? And then you need to make sure that you ask for what's called a settled as agreed letter to be sent to the credit reporting agencies so that it'll be taken off your credit reports. All right? So there we go. Thanks for the time.